Hi, my name is Christopher Smith, and I'm a civil rights lawyer here in Nashville. Today I wanted to talk about wrongful convictions and wrongful conviction lawsuits, which is something we've been handling a lot lately. A very rewarding area of law, but one that is very difficult for a lot of reasons. There's a lot of obstacles in the way. You really need, a good lawyer to navigate that. So let's talk about the first obstacle. Let's say you've been paroled. You spent a lot of time in prison for something you didn't do. Now you're looking at your options and you're saying, can I sue? Can I sue for what I've been through, all the time I spend in jail that, I didn't deserve to spend in jail because I didn't do this crime? The answer is you can't do anything until your conviction is set aside or called into question. And there are different ways that can happen. Most obviously, if, say, a court of criminal appeals overturns your conviction, a court throws it out. Maybe you get pardoned by the governor of your state. Maybe you get your conviction expunged. If you are still in prison and you get habeas relief granted, a court grants your habeas petition, that's another way you can call your conviction into question. Basically, the Supreme Court has said that you can't attack your conviction through a civil rights lawsuit until that conviction has been set aside. And they don't want essentially every convicted inmate attacking what happened in their case through the civil rights system. So there was a case called Heck versus Humphrey that set what's called the favorable termination rule, which means until your conviction has been favorably terminated in your favor, you can't bring a civil rights lawsuit. So then let's say that you do that, right? You get it set aside, or you get pardoned, or your conviction gets expunged. Now what? Now the next obstacle is going to be the statute of limitations. And when does that accrue? When does that begin to run? And it's different for each state because there's no federal wrongful conviction statute of limitations. It depends on the state that you're in. And in Tennessee, where I'm making this video and where I'm licensed, it's 1 year. So you have 1 year from the date that your conviction is thrown out or you get your conviction expunged, 1 year to bring a federal civil rights lawsuit. That's the same in Kentucky, by the way, where I'm also licensed. Just a quick aside, Tennessee has a state statute that provides for up to $1 million if you were wrongfully convicted. You do have to be exonerated by the governor for that to kick in. Kentucky has no regime like that. It's one of a handful of states that just doesn't have a wrongful conviction compensation statute. So just be aware of that. Some states have these kinds of laws, others don't. So then you've got the statute of limitations. We just talked about that. The next thing is what kind of claims can you bring? The most obvious or common one relates to Brady versus Maryland, which puts a burden and duty on the prosecutor and the police in your case to disclose exculpatory evidence, evidence that might tend to prove that you didn't do the crime that they're charging you with. Another area of law would be coerced confessions, coercing eyewitnesses, things like that would result in due process violations. Now the trick here is it's tough and it's almost impossible to sue a prosecutor for something that they did while acting as a prosecutor. They have what's called absolute prosecutorial immunity, and whether they should or shouldn't is a matter of debate, but that's the law. If a prosecutor is operating as a prosecutor in the court system, they will be absolutely immune for civil rights claims related to that. So you really have to pin the misconduct on the detectives who don't get absolute immunity. Now they get qualified immunity, maybe, or theoretically it's available to them, qualified immunity, but not absolute immunity. So in the Brady example, you'll want to say that it was a detective that didn't disclose this material to the defense or even to the prosecutor, because you can sue the detective, but you can't really sue the prosecutor. So that's kind of a limitation. So those are typically the kinds of claims that we see. There's a lot of work that the Innocence Project does on DNA evidence. That's kind of their mandate. If there's DNA in a case that might tend to prove, as a matter of science, that the convicted prisoner didn't do the crime, then they will get involved and handle those cases. But just because that happens, right? Just because the Innocence Project comes along and there's DNA that proves that you didn't do it, it doesn't mean that there's a civil rights lawsuit necessarily, which is why, it's important to have these state wrongful compensation laws, wrongful conviction compensation laws, because there will be obstacles, lots of obstacles that can arise in trying to get justice for the wrongfully convicted. But it's something that we're committed to. So if you or a loved one have a case like this and are looking, for wrongful conviction lawyers, send me an email or comment below, and we'll see if we can help. Thanks for watching.